Good evening. At this time, I would like to call the meeting to order. Today is Thursday, March 14th, 2024, and this is the meeting of the Rent Stabilization Commission for the City of West Hollywood. I'd like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Quiche and the Gabrielino Tonga people. I'll lead us in the Pledge of Allegiance. Please stand. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, may we have a roll call, please?
Yes, Commissioner Bass.
Here.
Commissioner Kerpes is absent for tonight. Commissioner Martz will also be absent for tonight. Commissioner Rory.
Present.
Commissioner Topshin.
Here.
Vice Chair Moore is absent for tonight, and Chair Wright.
Present, and we do have a quorum. If everyone's had a chance to review tonight's agenda, I'll entertain a motion for approval.
I'll move the agenda.
I'll second.
I already have a motion, and I have a second. Madam Secretary, roll call, please.
Commissioner Bass.
Yes.
Commissioner Rory.
Yes.
Commissioner Topshin.
Aye.
Chair Wright.
Aye. Motion passes. We have the minutes from last month's meeting, or last time we met. Has everyone had a chance to review them?
Motion to approve.
I already have a motion. I already have a motion, and I have a second to approve our meeting minutes from February 22, 2024. Madam Secretary, roll call, please.
Commissioner Bass.
Aye.
Commissioner Rory.
Aye.
Commissioner Topshin.
Aye.
And Chair Wright.
Aye. Motion passes as well. Do we have any public speakers this evening?
Not at this time.
You still have time, public, to get down here. Okay, item number 7 on the agenda is the manager's report. So for acting rent stabilization manager, Gloria Vilas, the floor. Nope, she's not here. The acting manager of rent stabilization.
Good evening, Chair and Commissioners. My name is Yasmin Spiteri, Rent Stabilization Information Coordinator and Acting Manager for tonight. On the look-ahead calendar provided in your agenda packet, you'll see we have an appeal tonight for D case number 4741 CD1. At the March 28th meeting, you will have one appeal, and at the April 11th meeting, you will have one appeal and a presentation on the Justice for Renters Act. That concludes my manager's report.
Thank you, Yasmin. Are there any questions for staff? Alrighty, that brings us to item number 8 on the agenda, which is our appeal, D4741 CD1. The address, 1237 North Orange Avenue, number 6. We have all of our parties in chamber, so if the parties will listen up, I will explain what the rules will be for this evening. Both sides will have 5 minutes to present their case. The appellant, in this case the tenant, will have 5 minutes that they can choose to divide. So you may divide it into 2.5 minutes to present your case and 2.5 minutes for the rebuttal. You can do 3-2. The division is up to you if you want to divide it at all. The respondent, in this case the landlord, will have 5 minutes and your time is not divisible. When it's your turn to speak, I ask that you state your city of residence and state your name and your preferred pronouns. The appellant will let me know how they want to divide their time, and we'll ask that you please stick to only the issues that are on appeal, although we would want to hear what you have to say about the other things. Unfortunately, because it's not appealed, we can't make any decisions on it, so please use your time to speak about only the issues that we can decide on this evening. Once it's your turn speaking, do wait at the microphone because the commission may have questions for you. Legal counsel, can we have the staff report, please?
Just a quick note, with guidance from the city clerk, we are providing the following accommodations. Commissioners will need to ask one question at a time. There will be an interpreter who will translate the questions, and the appellant will answer through the interpreter. An additional 2 minutes will be added to the tenant's oral argument, which they can split as they choose, for a total of 7 minutes instead of the usual 5.
And the additional 2 minutes, that's for the interpretation portion? Okay. Thank you. Mr. Natalizio?
Thank you, Chair. So good evening, Chair, and other members of the Commission. My name is John Natalizio. I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal hearing results from a hearing examiner's decision, which is granting a request for a compliance determination filed by the landlord for several issues relating to both the unit and the building common areas. In relevant summary, the original decision granted a rent decrease as follows: removal of debris from the front entrance for $28, repairing leaks in the unit's roof for $100, repairing kitchen wall for $26, restoring the on-site washer for $80, restoring the on-site dryer for $80, cleaning and maintaining the stairwell for $37, restoring or replacing the furnace for $200, restoring internet access for $5, restricting construction hours for $40, and fixing electrical interruptions for $5. The landlord filed a request for compliance determination stating that all of the issues identified had been complied with, which warranted a restoration of the rent. Tenant timely objected to the request and submitted documentation. The hearing examiner issued the first part of the compliance determination, which noted that tenant's objections did not challenge these specific issues relating to the stairs, construction hours of operation, and the electrical interruptions. Therefore, the hearing examiner found compliance with the order in the original decision and restored $82 in rent. And this first part of the compliance determination was not appealed and is therefore final. As to the remaining issues, on September 19th, 2023, a notice was issued to all parties that the hearing was scheduled for October 4th, 2023, and this notice was mailed by city staff to the party's address, including tenant's address, and tenant did not appear for the hearing. The hearing examiner issued a second part of the compliance determination, which restored the rent for all of the outstanding issues remaining from the original decision. The hearing examiner found that landlord had met its burden in establishing that it had performed the work required in the order of the original decision, and that tenant's failure to appear at the hearing resulted in tenant not meeting his burden to prove that compliance had not been achieved. Tenant filed an appeal, which claims that the decision is not reasonably supported by the findings made or evidence in the record, and specifically, tenant alleges that he did not receive the notice of the hearing for the compliance determination and claims that, the compliance determination hearing, and claims that certain work was not done in compliance with the original decision. Regarding the issue of notice, as outlined in the staff report, staff finds that the evidence in the record supports that the staff met its burden under the regulations by mailing the notice to the tenant and to the landlord. Regarding tenant's generalized statement that work was not performed, staff does not find the record lacks substantial evidence to reasonably support this second part of the compliance determination. Therefore, staff recommends adopting Resolution RSC 24-645. You, as the Commission, have the power to affirm, reverse, modify, or remand the appealed decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the Commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the Commission applies an independent or de novo standard of review to those conclusions of law. Thank you.
Thank you. Are there any questions for staff? Yeah. Commissioner.
Thank you, Chair. Mr. Natalizio, very quickly in the report under analysis, you mentioning that additionally site inspection may be ordered for the purposes of determining compliance. As I understood, there was no inspection in this case. Can you remind us, well, first, why would we need to include this in the report, this comment? Is this a general information? And what would be the circumstances when the inspection would be necessary?
Sorry, are you talking about on bait stamp page 13?
Correct.
Oh, so that part is just a summary for the commission for compliance determinations. Since that is just a different process than our traditional hearing standards, I've included those in our compliance determination staff reports, just 'cause I think it's helpful. If it's not helpful, let me know and I can take those out. But because it's a different process, I think it's helpful to note that. But in this case, yes, there was no site inspection done, and site inspection is purely within the discretion of the hearing examiner. So if the hearing examiner believes that one is necessary, they can order one. If they don't believe one is necessary, they don't have to order one. The regulations don't provide any further guidance on that other than it's within the discretion of the hearing examiner.
Okay, so that would be based pretty much per discretion of the examiner. So, and it was not, for this case, there was no need for the examiner to schedule an inspection.
Correct.
Okay, thank you.
Are there any additional questions for the commissioners? All righty, we will begin the hearing portion. So if the tenant, Mr. Alexander Konadov, would come to the microphone. All righty, good evening. And as a reminder, just have him state his name, city of residence, and let me know how he wants to divide his 5 minutes, which 7.
Alexander Konovodov, 1237 North Orange Grove Avenue, apartment number 6. West Hollywood 90046 is the zip code. And you want to split the time in half. And then he will be splitting his time down the middle, I guess, is the option.
Okay, perfect. And he can begin when he's ready.
Good evening to everyone.
Я узнал о том, что мне пришло письмо, что было решение принято на hearing, а меня об этом не оповестили.
He was notified too late about the hearing that he had missed, and he believes that he was not notified by proper channels he didn't receive correspondence. In the first meeting, he received correspondence, but for the second meeting, he received no emails, no certified mail, or no regular mail.
And please have him speak into the microphone so it can be recorded.
Пожалуйста, говорите в микрофон, чтобы ваш голос записан для рекорда.
Также я обратился в Stabilization, и они сказали, что они посмотрят, но не было найдено ни тракинг номер, ничего, чтобы подтвердить. Тракинг номер, чтобы подтвердить, что мне что-то прислали.
So when he appealed to the Rent Stabilization Commission, I guess not appealed, but when he addressed the issue with you guys, nobody was able to provide him with like a tracking number for the mail, for the correspondence. There was no email that was able to be shown to him as being sent that he didn't receive, so he believes that there's no essentially evidence that somebody tried to contact him.
В связи с этим я не имел возможности, чтобы не имел никакой возможности, чтобы показать свои документы, показать видео, показать фотографии, показать все, что у меня есть факты.
So, and despite the fact that he has supporting evidence, the evidence to support his original claim, he feels that because there was no proper channels of communicating with him when the meeting weren't followed, he never got the opportunity to essentially present his case in full, in thorough detail.
Ну, в связи с тем, у меня есть документы, но это не то место, где это надо решать, поэтому я бы просил, чтобы, если можно, вернуть обратно для хиринга, и чтобы там они рассмотрели мои документы. Да, дело.
So he still is in possession of all the evidence that he supports his original claim, but he understands, based on the instructions we heard earlier, that today is not the forum to discuss the actual details of the case as it was, and he's just basically appealing to you guys to get another opportunity, another hearing, essentially, so that he can get in a proper forum the ability to show you the evidence that he has to support the original claim.
Все.
And that's basically as it stands, that's his position right now.
And how much time has elapsed?
They have 58 seconds left, in addition to the 3.5 minutes.
Understood. Are there any questions for the tenant at this time? Commissioner Rory?
Are we allowed to ask questions after we hear from the other side?
Yes.
Okay, then I'll reserve.
Okay. Alrighty, so for now, you may take your seat. We'll have the landlord come up. He'll present his case for 5 minutes, and then you'll have 3 minutes and 58 seconds to complete your rebuttal.
Okay. Они приглашают на все, чтобы ваш лендлорд сейчас представил его случай на 5 минут, и потом у вас будет 3 минуты плюс 58 секунд, которые у нас все еще осталось, чтобы закончить. Thank you.
Okay, thank you. Alrighty, good evening.
Good evening, Commissioner, and good evening, Chair and Commissioners. My name is Charles Eberly. I reside in Beverly Hills, California. I'm representing Orange Grove 1 LLC. I'd like to start out, I know it was a long laundry list that you heard about problems in this building. Well, we were rehabbing the property at the time, so he was the only tenant left in the building, and there was a lot of construction going on. So that's all been completed, but we're not here tonight to go over that stuff. But as far as his ability to make the hearing, we all received notices from the city of West Hollywood. His address did not change. I see no reason why that should be an excuse for him to be allowed to reopen the hearing. I mean, it was sent, the city of West Hollywood sent the same notices to our side as they did to him, and he attended all the other hearings, so I'm not sure why, he wants to make this claim now that he didn't receive any paperwork. So that's the only thing I have to say about this matter.
Alrighty, thank you. Are there any questions from the commissioners for the landlord? Alrighty, thank you, sir. You may take your seat. Alrighty, the tenant will come back to the microphone. And you'll have 3 minutes and 58 seconds for your rebuttal.
Oh, excuse me, Chair. They'll actually have 4 minutes and 28 seconds.
Thank you.
У вас 4 минуты 28 секунд. I'm sorry, what's the next step?
He can rebut what the landlord said. He can essentially conclude defending his appeal.
Время принадлежит вам. У вас есть, вы можете ответить то, что сказал ваш предыдущий лендлорд, в смысле имеется в виду, почему они получили корреспонденцию, а вы нет. Или вы можете обсудить любую другую тему, связанную с этим апеллом, после того, как вы услышали его позицию.
Значит, я не знаю, по какой причине мой лендлорд получил документы, я не получил. Также мне, и, по-моему, Даяна зовут, она мне тоже говорила, что они посмотрят, но никаких данных нету. Есть какая-то запись на обычное письмо, но никаких больше данных, и мне обычное письмо не пришло даже тоже.
So basically he feels that it's, even though the claim by the landlord, they received the correspondence, he's not questioning whether the landlord received it or not, but he's saying that since he hasn't, it's not the burden of proof on him to prove, like there should be some sort of tracking information or some sort of a sent email or anything like that. But he just basically maintains his position that he did not receive the correspondence and feels that it's not enough that the opposition side received that it's not enough of a proof that the opposition received their correspondence to say that he therefore is, I guess, essentially falsifying anything about receiving his. which he maintains that he did not receive.
И, в принципе, когда я звонил и разговаривал с супервайзером в департаменте, мне посоветовали, собственно говоря, сделать аппил на основании этого, и больше у меня нечего сказать.
When he was informed of the missed meeting, he essentially tried to contact, I guess, representatives from the Rent Stabilization Commission, and although they were helpful, they basically said that his form of recourse was this meeting. So all he really asked for is an opportunity to present a rebuttal that he feels like he was not able to do because of this lack of correspondence.
Еще одна вещь. Мне ни одного разу не прислали на русском языке. А когда я перевожу сам, получается, неправильный язык, тяжело понять, невозможно вообще разобраться.
And then the other one issue that he's had, I guess, throughout this process, which might be reflected in this issue we're currently discussing, is that he's received all the materials in English and found it very difficult using Google Translate and without going into, retaining an interpreter himself to completely understand all of the, elements that are going into this process. So he just wanted to note that he understands that's not exactly the issue at hand right now, but that's been a contributing factor to why it's been difficult to I guess, accomplish his goals. He maintains that he did not receive any information about the meeting that was missed, but we wanted to say, like, supplementally, that in the previous correspondence, not the ones that he says he missed for the meeting that was missed, but in previous correspondence, it has also been difficult because everything was in English, and it's very formal kind of an English language that's difficult for him to operate with.
Я прошу прощения у всех, мне очень тяжело концентрироваться в связи с моей инвалидностью, в связи с brain damage и остальными вещами. Просто прошу прощения, если я повторяюсь, либо что-то не то говорю.
He'd also like to respectfully apologize for the fact that this has created a situation where everyone's time is at stake here. He's been dealing with certain disabilities, including those of a mental nature that I don't think I'm qualified to really translate directly. As well as certain physical handicaps, and the fact that the correspondence that he has received was in Russian, and his health ailments have contributed to this process being somewhat arduous. So he apologizes for the fact that if this is, for the time that you guys are spending on this, and hopes that you guys can come to a conclusion that's beneficial to everyone.
Благодарю всех за внимание. Всех благодарю за внимание.
And he thanks everyone for your time. That's all he basically has to present.
Thank you. I know Commissioner Rory had a question, and Commissioner Bass.
Sure.
Less of a question, but just more of a, please tell him thank you very much for coming out tonight. And it was good to hear from him and thank him for coming.
Thank you.
I have a question. My question is, originally you had, we see in the evidence that one of the complaints was related to the mailbox. Have those been resolved?
В самом начале одна из проблем, которые у вас было в здании, были связаны с коробкой для почты. Знаете, где почту вам вставляют? Эта проблема была уже разрешена?
Да.
Значит, они починили проблему с... Да. He says, yes, that problem was resolved with the mailbox.
Commissioner Topchin?
Thank you, Chair. Quickly, you mentioned that all previous correspondence was in English, and you had trouble of translating or understanding everything. But did you receive all prior correspondence from the city of West Hollywood addressed to you, to your address?
Он спрашивает, что до корреспонденции, которую вы говорите, вы не получили, у вас, вы соглашаетесь, принимаете, что вы получили всю корреспонденцию до этого времени, да? Значит, для первой встречи, для...
Да, получал.
И это было сложно из-за того, что они были по-английски, но вы у вас нет никакого контеста к тому, что по тому же адресу вам прислали.
Ну, когда я пришел на hearing, мне помогали мне помогали там на хиринге разобраться. И я ходил на консультацию тоже. В City Hall они были очень добры ко мне, они помогали мне.
Okay. So he says, yes, he has received all the correspondence prior to that, and additionally mentioned that when he was actually at the first hearing, and I guess when he went to a resource center, they were helping him with his language barrier. But he does not deny that the correspondence prior to the correspondence about the last meeting, he received it in, in a complete, to the extent of his knowledge, like in full.
Got it. Thank you very much.
Of course.
Thank you, sir.
Look at that.
Благодарю.
When did he reach out to the city to say, oh, I didn't get this correspondence, or that he'd missed that hearing?
Когда был первый раз, когда вы сконтактировались с городом или с комиссией, когда вы поняли, что вы пропустили встречу и не получили корреспонденцию про последний митинг?
В тот же день, как я получил только почту.
Извините.
В тот же день, когда я получил почту, я не помню.
He's going to check, but it was the same. What he just said was that it was the same day that he received. He addressed the city the same day that he received correspondence that he had missed the meeting. But he wants to check something in his records real quick because I think there's a date on there that's specific.
Если они отослали декабря 5-го, то, наверное, через 2-3 дня я это получил, и я тут же пришел.
The document that he's showing is called the compliance determination. That is date of notice is December 5th. That when he received that document, he realized that there was I'm surmising here that he realized that there was a decision made that he wasn't present for, and the same day contacted the city of West Hollywood to let them know that he hadn't received correspondence for that singular meeting.
Если мне память не изменяет, в тот же день я сделал аппил.
And if his memory serves him correctly, it was the actual same day that he filed the appeal, I would assume. He said made the appeal to translate directly. So in short, December 5th would be the answer to the previous question. Я им сказал, что декабря 5-го, но объяснил факты, которые вы представили.
Еще я могу это... То есть, получается, я думаю, что в октябре, да, думаю, правильно.
He just reflected on it once again and says that it is correct that it would be December 5th, that he the day that he was notified about this is when he addressed the city of Hollywood.
Okay. And have you had any other issues with mail not being delivered that you're aware of?
У вас были когда-нибудь проблемы с почтой, что вам не доставили вашу корреспонденцию в прошлом, исключая этот случай про пропущенный митинг?
Да.
Были проблемы? He says yes, he has had problems with mail delivery before.
Can you, around the same time, around October, around that time
Вокруг того же
frame?
времени? Вокруг 4 октября или просто
Нет,
через все это время?
в районе этого времени я бы не сказал, что было намного раньше, до того вообще почты не было месяцами.
He says that at the time of the October 4th meeting, he wasn't experiencing problems with mail specifically, but there were points of time where he says that much earlier on that there was like periods of months where he was having problems with not all but certain mail.
Около 2 лет у меня
Around 2 years.
билы, задержка в биллах, у меня не оплаченные, потому что я не получал.
To the point.
Почтового ящика же не было.
Oh, because there was no mailbox for a certain period of time prior to that, he was saying that he's had problems with correspondence, for which he incurred some like late fees for his bills and things because things were getting lost in the mail over a period of time, 2 years, at a frequency which at some frequency.
И еще одно. Некоторые почтальоны знают о том, что я якобы там не живу, потому что им рабочие говорили, что этот дом ремонтируется и никто здесь не живет.
He believes that some of the postmen were told that the building was empty because he was a sole resident, and if he was to assumes that that might be one of the causes for this correspondence failure, essentially. But he's stating that as an assumption.
Okay, thank you. Are there any additional questions? Commissioner Bass?
But just one last thing. He says it was the actual postman when he saw them finally that he talked to, it was the actual postman who told him that they were informed that the building there was no tenants there, so they were not, I guess, delivering mail.
Около 10 жалоб я с ними. И сделал с почтовым отделением.
So he says he's got over 10 complaints with the post office regarding not receiving mail over a period of 2 years or so.
Do you have a question, Commissioner Bass?
I have a question for staff, which might lead me to a question for the tenant. One quickly. Who is considered the applicant in a compliance determination?
The landlord would be the applicant.
Okay. In that case, I do have a question for the landlord, if that's not completely inappropriate to ask that question when the tenant's done.
Yeah, I think that's fine. I'm happy to recall them back up. Are there any additional questions for the tenant? All right, at this time, you may return to your seat. We have one more question for the landlord, and then we'll deliberate, and then we'll make a decision this evening.
Diane, is the packet at the podium? Thank you.
I'd like to present something to the commissioners.
So you've already used your time, so right now we can ask questions, and then we'll go from there.
Excuse me, Chair. I mean, I'm not allowed to contradict what he's saying, especially about mailboxes. Because I can see where you're going with this situation, and unless I can show evidence that there was a substantial mailbox there, that puts me at a disadvantage.
Well, both sides were given the same amount of time, essentially, because he's the.
But I didn't. But he brought it.
Excuse me, sir. Because he's the appellant, he has a rebuttal. You aren't given a rebuttal because you're not the appellant. Typically, we don't recall parties up to ask questions, so we are doing this now. But other than that, you've had the opportunity to present your case. If you're able to weave that into your response, if it fits into a question that we're asking. Otherwise, the rules are the rules, and we do have to follow them, so it is a fair process. Go on, Commissioner Bass. And yeah, no decisions have been made.
In the packet in front of you is the same packet we have. And on page 37 is the hearing notice for the compliance determination. And I'll wait for you to, it's thick like this, yeah.
You're talking about this right here?
Yeah.
Oh, okay.
That's all the evidence that we see before the meeting.
Okay. Page 37?
Yes.
Okay. Okay.
That looks like the hearing notice that you received about the compliance decision.
Yes.
About 2/3 of the way down in bold, it says Rent Stabilization Regulation 60010D requires posting this notice by the applicant in a conspicuous place on the property at least 5 business days before the hearing.
Right.
Where did you post that? On the property before the hearing?
I would have to, most of the time, my supervisors will post it right at wherever their mailboxes are located.
Okay, do you have any proof of that? Any evidence of that?
I don't, not tonight.
Okay, thank you.
Commissioner Topchin?
Just to clarify, since the tenant mentioned during the testimony that was there anything posted by you or your office on the premises, kind of a notification to the postal office that the building is vacant or anything of that nature? Have you contacted the postal office to ask them not to send the mail, anything of that nature, if you recall?
At no time while the construction was going on was there ever not a mailbox there for the tenant to receive their mail. And I have evidence showing that there was a mailbox that is a substantial mailbox that he was receiving mail at the time that the city of West Hollywood would have sent the determination of the last hearing. Would you mind? Would you like to see a
Can you
picture
speak
of that?
directly to the microphone, sir?
I'm
so
sorry.
that-
Would you mind seeing a picture of that?
I don't know if that would be allowed, if it's a new evidence or not. The legal counsel may
Is it
clarify
the same
that.
one that's on page 106 and 107 of that same packet?
This one?
This is what I'm saying.
Yeah,
what's the
that's
page,
one, but
Commissioner?
So we
this,
have that.
yeah, that's
Commissioner,
one.
okay.
Yeah.
So, but I still want to hear the response to my question. Had you contacted the postal office informing them that there is construction work or for any other reason, the mail should not be delivered to this property?
No, we never informed the mail carrier or the postal office that there should not be mail delivered. In fact, the mailbox was always outside where it was, and he had mail delivery every day.
Understood. Thank you, sir.
And can you affirmatively say that the compliance determination hearing notice was posted on property at least 5 days before the hearing?
I can't stand in here right now. It's a procedure that my staff has. They're very good at what they do. I would assume that they have, but I can only assume at this point in time.
Thank you. Did the hearing examiner ask if you had fulfilled that requirement at the hearing?
Not at the hearing.
Okay. Are there any additional questions from the commissioners? Nope. All right, thank you, sir.
Thank you.
Please take your seat, and we will begin deliberation.
Can we ask questions for staff before?
Absolutely.
Thank you, Chair. So, and I don't know whether the legal counsel or the representative from the department. Yes, ma'am. So if I appreciate very much the explanation of the procedure of the policy, which I didn't know that this policy exists when the staff member makes this specific work log or mail log under penalty of perjury, stating specifically that the correspondence was mailed and the way it was mailed. So I appreciate this. This is kind of new to me. I didn't know the existence of that log. So, but I would like to ask this question. And we had this type of cases, appeals before us in the past, where the parties would state they've never received the correspondence for various reasons. Here, there's construction, whether it's related to the construction for some other reason, or if it's a postal office failure to to deliver the mail. But is there any other way that the department could have delivered this notice to the tenant? Is this the only option, only method to mail it, or there are other methods, for example, a courier delivery or anything else? I don't know if the email considered to be a proper way of serving. So if you can just explain for us to know.
Sure. The regulation as it imposes the responsibility on the city is just it has to be mailed 10 business days. That's it. So it doesn't require that the party actually receive it. It doesn't say anything else. It doesn't say anything about email or personal service. It's just mail. To the extent that there are additional, like, for example, just courtesies like an email, or if there was, I don't know, a reason to do a courier, that'd be very expensive for the city to do. That would purely be as just a courtesy. But in terms of what is the city actually required to do, it is just mail.
In a way, the city concludes the process by mailing as it required, and the other way it could be guaranteed the party received the notification is because the appellant responsibility to post it in the common area. So they're basically, that also could be considered as a way of informing the party about the appeal.
Sure.
Yeah.
Sure.
All right. Thank you, sir.
Are there any additional questions for staff before we close the record?
I guess I did have a
go ahead.
question for staff. My question is, for this particular case, for any of the issues that the tenant might still think exist, is there anything that's preventing the tenant from filing a new application with the city or a new request with the city saying, hey, I don't think these issues have been fixed as of the date I'm filing this, and allowing for some sort of future revisit to any issues that he thinks are not up to code right now, or not up to code, but to his liking at the moment? Is there anything that prevents him from asking for a relook at what's happening?
So generally, there's a six-month prohibition. I would have to look specifically at the language to see if it's, because this has been so long and these are compliance determinations, but it is within the commission's purview to the extent that that 6-month filing requirement applied in this scenario, it could be waived. So if you wanted to, you could waive that, and then, for example, the tenant tomorrow could immediately file a new application.
And have these issues revisited?
Yes.
Okay. That's my question.
Any additional questions? Alrighty, we will close the public hearing on this and begin deliberations. Are there any volunteers to start off our deliberations?
I could try, Chair, and I'm going to be very quick.
Thank you. For volunteering, not for being quick, sir.
Yes, thank you for. Well, after hearing what I heard and, of course, reviewing the record before us, I believe that we should affirm the staff's recommendation in the compliance determination, because the bottom line is what's important here is that I see that the city, the department met the requirements under the law to properly mail the notice. So I don't have any reason not to believe what is here, especially when I see that the staff member is required to enter a mail log in their system under penalty of perjury after mailing the correspondence. So there's no reason for me not to trust this happened and this was followed. And also the tenant's statement then things were not repaired or something like that. It's not specific to what was not repaired, so we don't know what was not repaired. Maybe there are things that were not fixed or repaired. That is a possibility. But I would say, and I echo what Commissioner Rohrer said, is just we could waive the 6-month waiting period for the tenant to file a new application, new request for hearing, if there are specific items or issues that have not been repaired. So I would support the staff recommendation, but with the modification to waive the 6-month period for the tenant to file a new application, if the commissioners will support that. Thank you.
Thank you, Commissioner Topchin. Commissioner Bass?
Commissioner Topchin, I'm just going to have to take exception to in the request for an appeal, the tenant did say that things hadn't been fixed, but when I'm looking here at pages 47 and 48 in our packet, and there is a very long list of things that are, some of them repaired, some of them not, and then it says there are 20 pages of photos, which then follow. So I do take exception to the suggestion the tenant didn't say specifics about what hadn't been repaired. I see it here and in 22 pages. So a hearing is not required for a compliance determination. As I understand it, and staff will wave their hands at me when I get something wrong, I'm sure, so I'll watch for that. But as I understand it, the landlord can file for a compliance determination and the hearing examiner can look at that evidence and an objection, if one is made by the tenant, look at that and just make a decision without a hearing. There is no requirement for a hearing. However, if they do decide to have a hearing, then there are notification requirements. And I've only been on this commission for 9 months or so, and we've heard one other case where somebody appealed to us saying that something had not been posted on site, therefore they should have a new hearing. What was not at dispute at that point in time was that they had received the mail. So they were arguing before us on a technicality that had not been met. In this case, we're hearing that there was nothing posted or received in the mail by the tenant, so neither of those neither of those happened, and all we are hearing is that it is very likely that it was posted, and I believe that the landlord probably made that effort, but we have no evidence in the record anywhere, nor oral testimony tonight that tells us that it was done. So at that point in time, I'm left to believe that there probably was not. Was it posted and torn down, blown off by the wind? We've had a lot of rain lately. There are a lot of reasons why something could have been posted, but the tenant never saw it, and we have no evidence that it was. I believe the staff 100%. I know that they mailed it, but I also know that there have been things mailed to me from the city that have not been received. Still haven't been reimbursed for my background check for this job in the last 9 months, but that's only $30. But I think that's been mailed and not ever received. I also know where I work, huge facility. I work for the LA LGBT Center, and for about a year, we lost a lot of money because checks were being mailed and just not received. And we don't know where those went. The post office was redirecting them to someone we got forwarded back to us, but it was redirected to a place downtown, not related to the LGBT community or anything like that. The point I'm saying is the post office, unless it's a certified letter, doesn't mean it was received, which is why I believe the code has this other requirement for posting, and we have no evidence of that. So I've said a bunch of different things. I think the hearing examiner probably could have made this decision based on the evidence, and it might have come out the exact same way it did. But the hearing examiner decided they needed to have a hearing, and then the tenant is saying they got no notice about that. And I see no evidence that they did actually receive that notice. So for that reason, I would recommend that we remand this for a new hearing.
Thank you. Commissioner Rory?
Well, I'm open to hearing what the rest of the commission has to say. I think off the top of my head, this is an interesting matter that perhaps raises a potential for a future discussion, agendized, of course, as appropriate, about notice and perhaps recommendations to council about amending the code to allow for additional forms of notice. I'll just leave it at that as a possibility. But what we're here with tonight, I think that there has been, I wouldn't say there's no evidence that there was a posting. I think there was testimony that there was an assumption that there was a posting and no other corroboration, but there was testimony of an assumption of a posting. I tend to want to support the discretion of the hearing examiner. And I tend to want to affirm knowing that there would be a potential for the filing of another request for hearing if we were to waive certain requirements. But I'm not predisposed to any one of those, so I guess I'll kick it over to Chair to see what her thoughts are.
Chair, if I may, to make a correction, I appreciate Commissioner Pass. I withdrew my comment when I misspoke about the not providing a list of the items. Clearly, there is a list of things that were that the tenant claims that were not corrected. However, I still believe this was the examiner's discretion, and I don't believe we need to change this outcome. I still believe we need to support the staff's recommendation with the 6 months waiver. And I don't believe this is a case when we need to send it back, remand it to the examiner. Thank you.
I think this case, simple issue, but it feels like a sort of a tough decision to have to weigh in on. I think there is, on the one hand, the landlord, showed up to the hearing, gave presentation under oath, and we have, the outcome of that. And then we have the tenant who had received all of the other correspondence, but didn't receive this one. And I don't have any reason to believe that, that's not the truth. We also have the log from staff where they, swore under penalty of perjury that they mailed the document. And I think that satisfies that notice was sent. I think I would feel sort of more sure, more certain if we, could have gotten an affirmative response that the notice was posted. But outside of that, it's really speculation, of why he didn't, sort of why he didn't receive it. The only thing we have is sort of the speculation and the possibilities of that. And our decision can't rest on that. I do have to believe that the hearing examiner, heard the testimony, reviewed the evidence of record, and made a decision based on that. And because I don't have anything to disrupt that decision, I am inclined to affirm the hearing examiner's compliance determination with the caveat that, the 6-month period to refile, that's waived. Because at the end of the day, if there are issues that haven't been addressed and haven't, been fixed, or new issues have arisen during the construction or sort of whatever's happening there, I do want the tenant to have an opportunity to enjoy where he's living and have an opportunity to bring that before a hearing examiner. And so I would be inclined to affirm the hearing examiner's decision with the waiver of the 6-month period. Commissioner Topchin?
I can make a motion, Chair. I can make a motion.
You want to make a motion? Did you want to chime in, Commissioner Rory? No? Okay. All right, we're ready for a motion.
Okay. I make a motion to adopt resolution RSC 24-645, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's compliance determination as to application number D-4741 CD1 with a caveat that the 6 months period to file a new application will be waived.
And to be clear, part of that motion, it would be a waiver of regulation 600054.
As stated, yes.
A second. We have a motion and a second by the chair. Madam Secretary, roll call, please.
Yes. Commissioner Bass?
No.
Commissioner Rory?
Aye.
Commissioner Topchin?
Aye.
And Chair Wright?
Aye. The motion passes. To the parties, if you have any questions about the decision or anything sort of with the case, you can call the Rent Stabilization Division at 323-848-6450 or email at rsd@weho.org. And just as a note, just based on some of the comments from the landlord regarding language accessibility, I hope we are able to address that and make sure that the materials that are going out and are, in Russian or language that he understands, and that also a translator is available for that assistance. I don't know if it's being done. I'm not saying it's not. I just want to make sure that that's noted and that we are making sure that our residents, do have what they need and are able to communicate in the ways that are more comfortable for them. Alrighty, item number 9 on the agenda is new business, which there is none. Item number 10 is items from staff. Do we have any items from staff?
Yes, I have a couple of items. The first is an announcement. Our monthly educational forum in partnership with CES, or the Coalition for Economic Survival, will take place on March 26th at 6 p.m. via Zoom. Those who are interested in attending can reach out to the Rent Stabilization Division at 323-848-6450 or email rsd@weho.org to RSVP. And secondly is regarding Commissioner Martz. As we heard at the last meeting, this would have been Commissioner Martz's last meeting, but unfortunately, he wasn't able to join us tonight. And in his absence, he submitted a letter for us to read to you, commissioners. So I'll read that letter now. Dear Rent Stabilization Commission members, as my tenure with the Rent Stabilization Commission of West Hollywood comes to an end, I want to take a moment to express my gratitude for the opportunity to work alongside such dedicated individuals. Together, we addressed important rent stabilization issues and countless appeals, striving to make a meaningful difference in the lives of our community members. The experiences and insights I have gained during my time on the commission are invaluable, and I am proud of the work we have accomplished together. The discussions, spirited debates, and decisions we've navigated have hopefully contributed to the betterment of West Hollywood. I look forward to seeing the continued success and impact of the Commission's work and hope our paths may cross again in the future. Thank you once again for the support, collaboration, and camaraderie. I also want to give my deepest thanks to our city staff who work so hard to provide the Commission with all we need to be successful, from administrative work to legal counsel to the rent stabilization team, the facilities personnel, the block-by-block and sheriff teams, etc. Wishing you all the best in your ongoing and future endeavors. I leave you with this haiku. Rent's gentle balance in West Hollywood's embrace, guided by wise hands. Warm regards, Kellen Martz. Yes.
I want to hear that again.
Yes.
Please.
Rent's gentle balance in West Hollywood's embrace, guided by wise hands.
Thank you.
Thank you.
Yes. I also wanted to take a moment to thank Commissioner Martz on behalf of the Rent Stabilization Division for his service on this commission. He brought a wealth of dedication, wisdom, and expertise to our deliberations that enhanced the discussions and decisions. His insights and experience have proven invaluable in guiding us through the numerous cases and appeals, and he leaves a lasting impression on all of us. While we feel a sense of loss with his departure, we're also excited about the opportunities that await him in his new role in the City Attorney's Office, and we're confident that he will excel in his new endeavor. You will be missed, Commissioner Martz. Thank you. That concludes my comments.
Thank you. Items from commissioners. I'll start with Commissioner Topchin.
Again, thank you, Chair. This is one of these great moments. Then, I'm happy for Commissioner Martz, obviously, and I wish him good luck in his new endeavor. But I'm going to miss him. He was very funny, very energetic. It was fun to sit next to him, and I will miss him. Kind of his arguments. This bright legal mind that sits next to me, and he jumps in with appropriate, very interesting thoughts, thoughtful comments. So he's a wonderful person, so I wish him well, and I'm going to miss him, and we will. Obviously, the commission, hopefully, sometime in the future, will see him somewhere. So he still lives in West Hollywood, but probably going to meet him somewhere in Gelson's or Trader Joe's or anywhere else. So good luck to you, Commissioner Martz, former Commissioner Martz now, if you watch us. Thank you, Chair.
Thank you. Commissioner Bass.
I'd like to join the chorus thanking Commissioner Martz for his service to the city. It was nice to serve with him for a short period of time, but even prior to that, I was grateful for his advocacy on behalf of renters in the city, and I'm grateful for that. And I just appreciate you all as well in that same vein. This was a decision tonight that actually I changed my mind while sitting up here. Walking in, I thought I was going to make a different decision, and so I just appreciate that we're able to debate and disagree and do it in a way that hopefully moves our city forward, and I appreciate that about all of you. Thank you.
Thank you so much, Commissioner Bass. Commissioner Rory.
To follow up on that, I appreciate how much this commission really dives into every appeal, and you can read it, and then when you get up here, you hear everyone's comments, and I'm just impressed at the level of detail that everyone puts in to each of these meetings that I've been. And Kellen, if you're watching at home, good luck at your new firm and in your new role. And it was awesome having you up here, and I thought you brought a lot of, like a steady rudder to a lot of the discussion, so I'm going to miss that. And I'd like to request that we adjourn informally in Commissioner March's honor.
I thought you were going to say memory. I was like, he's still around.
Service.
And I think Commissioner March was probably one of the first folks that sort of welcomed me on board and sort of was giving me advice, et cetera. And so I certainly will appreciate his congeniality and camaraderie and just his directness. It's always interesting to do something with another attorney, and he was certainly just always was able to get to the heart of the issue, and I really appreciate that. I appreciate his clarity in being able to see and bring up very interesting points, and so our loss, but the city attorney's office is gain. Additional comments, Happy Women's History Month. Last night in these very chambers, Hollywood Now in the city of West Hollywood gave an award to Abby Land, the Herstory Award, the 8th annual. And so I just wanted to congratulate her. There are events, I think, throughout the rest of this month. There's a festival, a dance party. Check the city's website, weho.org, for all of the Women's History Month events. They are some really interesting ones, some really fun ones, and so I hope that folks come out and support the amazing work of the Women's Advisory Board and the City of West Hollywood and all of the other organizations that are participating. And on that note, the next meeting of the Rent Stabilization Commission will be held on Thursday, March 28th, 2024 at 7 p.m. Same place, same time. Have a great evening.
One quick question. Sure. Is it possible to, where would he be able to, I guess, get a record of the decision made tonight, and how can he go? Oh, okay. Thank you so much for your time.